You can just go to markstevens.net. You can look on their success stories. This is not the first time this has happened. However, a little bit of distinction here. This is extremely explicit. There's no ifs, ands, or buts about it. So when critics lie and say, well, Mark Stevens is a jackass, he can't produce one single court case number where any of his motions have been granted or anything has ever been thrown out, it's not true. But this one I am able to post unredacted. So I want to thank Tait. He was online today, but I guess he wasn't able to stay and join me on the show. Hopefully next week we can get him on. So I'll get this document up. I guess it'll be up here. It's a scheduling order from a David Wambach, and it's the Circuit Court in Jefferson County, Wisconsin. And it states, it's pretty clear, the plaintiff will file a response to address the pleadings, which is the motions to dismiss, that I helped Tait with no later than 4 p.m. on February 26, 2016. And that was signed by this judge on, I guess, it looks like the 17th of February. Well, the same day, the next day, it looks like a Jeffrey Schock said, Dear Judge Wambach, I write in response to the court's scheduling order dated 17 February 2016. The pleadings submitted by the defendant have no basis in law or fact and therefore should be denied. No basis in law? Okay. Supreme Court has said it's an adversarial system, and the Supreme Court has stated that to be a true adversary, you have to have damage. You have to have an injury and damage. So, yeah. But I guess none of those Supreme Court cases apply to Mr. Schock. No basis in law or fact, therefore should be denied. Now, that's typically all one of these prosecutors have to say to get something tossed out. But you can see he signed it, Jeffrey Schock. He's got a state bar number. And a copy was sent to, and there's the case number, which is great. This is the actual case number. So he didn't actually address directly anything. He just did the blanket. It's all gibberish. It has no, he just lied. It does have a basis in law, in fact. You just disagree with it. So instead of addressing each point, which he cannot overcome, he can't show injury and damage. It's ridiculous. He can't show any evidence showing that his claim is true. So he just, no basis in law or fact. Thank goodness this judge did the right thing. So we go to this other page. There we go. Decision and order signed on the 7th of March, 2016. Case number 15TR9085. So there's your case number. The court scheduling order required a response by the state to the issues raised in defendant's motions and ultimate relief requested, a dismissal, based on a lack of evidence proving jurisdiction. The state's reply is conclusory and contains no analysis, no citation to authority, nor any application of facts to the law or an explanation why such an application is unnecessary by the court. Therefore, the court grants the relief defendant seeks. Case dismissed. The trial date is removed by the court. David J. Wambach. Boom! That is evidence. Now, of course, this will be spun by these trolls. Those, it was just traffic. It doesn't count. When we said you didn't provide any case numbers, we didn't mean just stupid traffic. No. We meant murder and really difficult. No. This is what we call evidence, something they're lacking. I think this is really outstanding that the judge actually wrote he actually did the right thing here, which is unbelievable. The prosecution must be so used to getting their way. I have to repeat this. It's worth repeating. The state's reply is conclusory and contains no analysis, no citation to authority, nor any application of the facts to the law or an explanation why such an application is unnecessary by the court. I got to tell you, bravo. I mean, this man, Wambach, may be part of a criminal organization, but he clearly did the right thing here. Outstanding. It's shock. I'm in shock that the judge actually did the right thing. I mean, we get these things tossed out, but my gosh, to spell it out like this. So maybe what I'll do in the video, I'll post screenshots of the trolls actually saying that I've never presented any case numbers. I've never helped anybody get something thrown out in court. There you go. Maybe what we could do is start attaching this particular video, to those comments. But it doesn't ultimately matter because nobody cares anyway. It's not true. And people who are honestly looking for the truth are going to see the evidence on the website. Somebody really interested in, well, let's see, is this guy right? Is Mark really lying about having things thrown out? Just go to the markstevens.net, just click on the success stories. This will be the latest one for March 19, 2016. And there you go. That, I'm in shock. Tait had said that this was thrown out, but I didn't expect something so clear. Again, I'd like to be able to see what the critics are going to say. You can't get much more clear than that. And that's what, so I'm not only glad that it says that, but I appreciate and thank Tait for allowing me to provide this evidence unredacted. So you've got the case number, you got the judge's name, we got the prosecutor's name. This is outstanding. Not that it really makes that big a difference, but the only thing that the critics can say now is try to marginalize this and just it was just traffic. But someone's asking me if I have the dude's exact motion to dismiss. Yeah, I have it available at markstevens.net. I had explained because things were a little bit rough initially for Tait. Things weren't all, sunshine and unicorns. But I suggested that he break the motion to dismiss up into several motions. So it's not as easy for the judge or prosecutor to just say, denied. There's all these issues here. So what was so the point, why this is also so significant and why you can dismiss any marginalizations. Oh, it's just traffic. It's not like it was a possession charge. We had that thrown out in Idaho too. Felony. What's so significant here is that the same challenges that we would make in a possession case, a charge, or taxes, or something more serious than traffic, we make the same challenge. We're striking at the same root, and that is the foundation of the prosecutor's claim against you. It all hinges on the same damn opinion. If you're physically in Wisconsin, our laws apply, and we have territorial jurisdiction, which they use to support their claim of subject matter jurisdiction because you violated their code. It's the same thing. So any marginalization of this, you can shrug off, or you can challenge them and say, wouldn't Mark be making, and hasn't he made, or wouldn't I be making the same challenges if it was a felony possession charge? Isn't a cop making the exact same argument or the same opinion to support his possession felony charge as the cop does on a no driver's license charge? It's the same damn thing. And it has no more evidence in the traffic situation where he didn't even try. He didn't even try. If it was so obvious that the laws apply because you were physically in Wisconsin, why wouldn't he just say, I already provided the evidence here, it's XYZ? He didn't do that. He just tried to say that none of it had merit, and the judge stated he didn't even try. There was no explanation as to why. And he did the right thing. So congratulations to Tait and to the trolls. Nice try, but now we've got even more evidence to show that you're lying. You got nothing. You got nothing. My name is Mark Stevens. Till next time, salud.